Hi, good evening. This is Talk to SWU Live, and again, good evening to you. I'm John McGowan. I'm the General Secretary of the Social Workers Union, and welcome. Welcome to another SWU webinar where social workers get the opportunity to ask employment-based questions. And it's great once more to see so many people registered, and thank you once more for giving up your time tonight. I appreciate that. So I'm hopeful that we will get through a lot of questions this evening. We've got 1 hour, but do remember that the advice offered for this session is as of today's date, which is the 30th of March 2023. The event is being recorded and will be available to review and share very soon. And importantly, working behind the scenes are the talented Sean and Joanne, so thank you, Sean and Joanne. And before we start, I'll take you through some of the housekeeping for this webinar. So please ask any questions in the live chat box, which will be to the right of the screen, and Sean and Joanne behind the scenes will make me aware of them, and I'll share them with the panel as we ongoing. And my advice to everyone is to please keep the comments brief and non-identification factors in any message, just to represent confidentiality. But before I introduce the panel, I just want to emphasise the need for us all to join a trade union. Of course, as you would expect, I'm biased. I would always recommend the only specialist social work union in the UK, which of course is the Social Workers Union, and SWU, working with BASWA, is indeed a terrific collaboration for the social work community. We are more at SWU, we are more than just skilled representation, and do please see the comments box for the info, which will be placed in the comments box regarding our campaign fund and also the SWU University assignment, just to name a few promotions. So now, really over to the what I would argue the most important people in this webinar, and I'll ask each panel member to introduce themselves. So I'll start with Paul.
Thank you, John. My name is Paul Scoley. I'm a solicitor at trade union law firm Morrish. We're based in Leeds, but we act for 29 different trade unions and professional associations throughout the UK. We only act for unions and people, not companies. And I've been working with SWU and John now for several years. And this is one of a number of webinars that I've been very pleased to participate in. And I'm looking forward to answering your questions this evening.
It appears John may have frozen, so I'll introduce myself in the hope that John will unfreeze shortly. I am Laura Sheridan, and I am one of the advice and representation team at BASWA. I'm trade union official for the Social Workers Union, and I've worked for BASWA and SWU for almost 5 years now. I'm not sure if we have a technical difficulty, John.
I think I'm back on again. Is that okay?
Yeah, good. Can hear now. Yeah.
That's the joys of technology for you, and it's been fine all day. So that's good, actually. It's given me time to put the first question into some format, and it says, Paul, a question for you, actually. Is that okay?
Sure.
It says, I'm a social worker in a local authority, and potentially another union separate from SWU will be striking. I'm not a member of the other union, but can I support the strike? So a question around strike.
Yeah, very topical at present, of course, with the strikes that have taken place throughout the professions and industry over the last 12 months or so. The law in relation to strikes is complex and difficult and deliberately designed by a government determined to make life as hard as possible for so the answers to nearly all questions about what's helpful about the law in relation to strikes is not, and that's not because we don't want to support their members or because lawyers are reluctant to challenge the status quo. The problem is simply that the law literally is designed to put a minefield in front of trade unions and their advisors to make it harder to strike. And this is one of those cases where what looks like a perfectly straightforward question, can I participate in a lawfully organised strike, is much more difficult than one might think. So that the short answer is this. If you're a member of a trade union that has not balloted for action, so in this case the question assumes that an other union has held a ballot of its members for strike action, and that ballot has been in favour of action, then you as a member of SWU can't participate in that strike action. Not lawfully anyway, and you won't be protected if you do. And if the union were to encourage you to do it, the union could be sued. And if you were to do it and to break your own contract of employment by striking, say, then you'd be liable to discipline and even potentially dismissal without a remedy, without even the protection of the law in relation to unfair dismissal, because your own union hasn't been through that process. Now, strangely, and again, it's an anti-union law, if you're a non-member of any union, then you can participate in lawfully organised strike action called by one union, but you have to be a non-member. So if you're here, I'm assuming at least some of you are SWU members. If you're a SWU member, and it's SWU membership that counts here, not BASWA, because BASWA is not a trade union, SWU is. If you're a SWU member, then the only advice I'm afraid I can give you is don't actively get involved in strike action. You'll not be protected from action by your employers if you do. Hopefully that's clear. If it's unhelpful, I apologise, but that's the way the law is, not the way I'd like it to be.
Thank you, Paul. And Laura, have you got anything to add to the strike question?
No, I think Paul's covered it. Thank you.
Yeah, I know, and it's a real frustration for us at SWU, because obviously we're keen to engage in local authorities and other organisations when there is a strike, but we need that contact and sort of collaboration. And unfortunately, despite trying that, you know, we need other big unions to engage with us and offer our support, but for some reason or another, it's not always forthcoming. So thanks for answering that one. And the next question, I'll just read this out for you if that's okay. It says, I work for an agency and receive a higher hourly rate than my colleagues who are employed by a local authority. I've noticed an atmosphere and overheard some comments about getting rid of agency staff. I feel that I have fewer employment rights as an agency worker. Is this true? I'm happy to say that question again. So I work for an agency, receive a higher hourly rate. I've noticed an atmosphere. So
yeah, okay.
Over to you, Laura.
Thank you. And again, the answer to it is not quite as straightforward as I would like it to be, but it all depends on what your agency contract and arrangement is. The most common arrangement we see with social workers when we're talking to people and giving them advice and sometimes representing them is what's called an umbrella company arrangement. So normally in practice, what that means is that the person, the social worker, is employed by the umbrella company. Actually, they kind of almost act as the employee and manage things like payroll and your tax and national insurance. And the agency gets paid a fee as part of your kind of hourly rate. That some of that hourly rate goes to the agency for placing you at the end user, which is the employer. So quite often that's with local authorities. So it's not always a straightforward arrangement in terms of establishing who the employer is. A lot of this came in when IR 35 came in, so it just made it a little bit more complicated, I think. But I think generally in terms of your rights as an agency worker, you are entitled to certain rights, whether you are an agency worker or a full-time employee, basically with the local authority. Protection from discrimination is one of those things that you have the same right to a full-time local authority employee, whether or not you are an agency worker or an employee. I think where agency workers can end up being more vulnerable, for want of a better way of putting it, is that very often, even if you are employed by the umbrella company, there's normally clauses in your contract or things in your contract as a temporary worker that means that you can have your both sides can terminate the contract within normally 1 or 2 weeks. Quite often we see a week's notice for either the employer to give you notice or for the employee to say, right, I'm leaving, I'm giving you a week. Some people, that's great because it gives you that flexibility to be able to move around employers, but it can put you in a vulnerable position if, for example, what we tend to see quite often with agency workers is someone's made a complaint against them, for example. Now, if you're a full-time employee of the local authority, they'll go through a full process. And if there's an allegation made against you, you know, this is worst case scenario, obviously, but it can happen. And quite often there'll be a disciplinary process that they have to go through with a local authority, and they have to do that because you're employed. With an agency worker, they can simply say, right, well, we'll just terminate your contract. You've got 7 days, and they don't always go through that process, which then leaves somebody vulnerable in terms of, well, how does that work in terms of working as a social worker elsewhere? Are you going to get a reference? So it can leave people quite vulnerable in that situation. So I think it's about knowing what the pros and cons are for agency work in terms of, you know, knowing what is the best thing for you. There are pros in terms of having that flexibility. Obviously, I think you've already said that quite often the pay, well, very often the pay is more with agency work. So you've got a higher rate of pay, you've got flexibility to be able to move, you know, between jobs, which works for a lot of people. But there is a word of caution in that the downside to that is you are more vulnerable, and you don't have those rights to claim something like unfair dismissal, for example, because you're not employed by that local authority technically. So if they end your contract, which is what you've agreed to do, you've not been unfairly dismissed. So the rights are less in terms of employment protection, and I think it's up to the individual whether they feel they have to think about what the benefits are to them and what the potential vulnerabilities are, really.
Thanks, Laura. And Paul, anything to add? In fact, one of the attendees have got a wee supplement to that. I don't know if you want me to ask that, or but Paul, regarding what Laura said, anything to add? Anything add on to that?
I think Laura's covered it well.
Yeah. So one of the attendees has asked that as an agency worker, the employer has not been supporting particular learning needs such as dyslexia and not understanding individual needs, and also some concerns about racism and bullying. So I think as an agency worker, you're still protected as part of the employment structure, Laura. Would that be right?
Yeah, absolutely. I mean, I think I said just in my answer that you have the same level of protection from discrimination as you would have if you were a full-time employee. You know, an agency worker, you know, there should be adjustments put in place if someone has a disability, regardless of whether you are a full-time employee or an agency worker. And protection from other forms of discrimination, absolutely. You do have a right to that protection. And I think I would say to anybody who believes they are suffering from discrimination as a full-time employee or an agency worker, keep a note of what is happening, and particularly keep a note of how the way you're being treated compares to your comparators, for want of a better way of putting it. Particularly, I would say, in relation to potential race discrimination, because it can be quite difficult. Many a time I will speak to members, and we know and they know that they are being treated differently, and that it is because of their race, but it's about proving that. So actually evidence of how you've been treated in comparison to your white colleague, for example, you know, and I think, you know, for example, if your white colleague's being paid or given toil and they're not giving it to you would be one example. But there's many that we've come across along the years. And so keeping a note of what's happened and how it compares to how your colleagues are being treated, I think is really important, because that helps to build up that picture. And if you think you are suffering discrimination, get in touch for some advice, because there are time limits for bringing discrimination claims. So we don't want someone to suffer for months and then not be able to bring a complaint or bring a claim about it if there was discrimination. So I would always say to people, if they think they're being discriminated against, get in touch with the A&R team and we'll talk you through it and talk you through what your options are.
Perfect. So thanks for that, Laura. And Paul, I'm just looking at the questions coming in. So this question's regarding discrimination. Would you be happy to answer this one? So it's does discrimination law extend to trans people? Am I protected if I have had to if I have had no gender reassignment treatment. So does the discrimination law extend to trans people?
Short answer is yes, but there's a longer answer that's probably more useful. Excuse me. The Equality Act 2010 now sets out the different flavours of discrimination that the law protects, and many of them are commonly recognised, like sex and race and disability and age and religion and belief and so on. And one of the protected characteristics, as they're called in law, is gender reassignment. Gender reassignment is not defined in terms of surgical change of sex. What's required is an intention or action that takes you down a step or a path, sorry, that will lead to a change in your gender identity. So even if somebody's had no treatment of any sort, no tablets, medication, no hormones, no surgery, of course, but nevertheless, if they can show that they've determined that that's a path down which they'll go in due course, then immediately they are protected as a trans person, and they get the same protections as a woman gets as a woman, or a disabled person as a disabled person. So they're protected from direct and indirect discrimination, and particularly, I think, relevant for trans people, harassment by colleagues or employers, victimisation, and so on. Since at the end of 2020, this protection arguably also extends now to gender fluid and non-binary individuals who might fall outside of what ordinarily one would think of as a trans person. A tribunal case against the Jaguar car company was successfully pursued by a non-binary individual. At the end of 2020, she was awarded, they were awarded in the end £180,000, and it was widely reported, but they'd not undergone any form of sex change treatment in the way that one might think of it, and certainly in the way that it was defined in the Equality Act 2010. The tribunal said, nevertheless, plainly people who are gender fluid and non-binary are included within the definition of gender reassignment for the purpose of discrimination law. That's what we lawyers call a first instance decision. It's a decision of a tribunal, not an appeal court. So it's not binding on other tribunals in the future. But interestingly, to me, it's now, what, 2 years, and I've yet to see a case go against it. So my sense of it is that there's a reasonably good argument now to say that trans people who qualify under the definition in the Act, and those who, not being strictly trans, nevertheless are gender fluid or non-binary, have the same sorts of protection in the workplace.
Thanks, Paul. That was an enhanced and very knowledgeable answer, so thank you. Laura, anything you would like to add to that answer?
I don't think I can add anything to that. I think that was, like, as you say, a very thorough answer.
Perfect, and thanks to the attendees. We've got some other questions coming in. We'll try to get round to all questions, so keep them coming in and we'll do our best to answer them. If they're not answered, then my advice to you would be, as I said at the start, to join a union and seek out some advice and sort of guidance where possible. But anyway, we'll do as much as many as possible. Laura, are you happy with the next question?
Okay, yeah.
So I'll read this out to you. So it says, I currently work 5 days per week and I want to cut it down to 2 days per week. I've worked for the same local authority for 6 years and have a permanent contract. I mentioned this to my line manager, who said it may cause difficulties. Can my employer simply reject my request to work part-time, or do I have to have a right to insist on a change of hours? So it's about the change of hours to part-time.
So I think there's two answers to that question. In terms of, can they simply reject the request to work part-time? No, they can't. There is a process they should go through. Can you insist on a change of your hours? Also, no, you can't. So I'll kind of go through the law with regards to that. I think you said the person had worked for the employer for 6 years, so obviously been there for a significant amount of time. The law around flexible working is that someone can apply for flexible working after a period of time working for the employer, and it's, I want to say 26 weeks. It could be slightly more or slightly less than that, but I believe it's 26 weeks. And obviously this person is well over that threshold for being able to apply for flexible working. So they are entitled to request flexible working, and normally employers have a flexible working policy and an application process that you can go through to make that application for flexible working. If not, then sometimes occasionally we see employers that don't have that process, but you can just put your request in writing to your employer. And I would always say to people, set out why it is you want, what it is your flexible working request is for, the reasons for your request. Now your employer, what the law says is your employer has to reasonably consider that request. So they can come back to you and say, no, that's not going to be workable, but there's a list of reasons that they can give really as to why it wouldn't be workable. The most common one we see is that it you know, for business reasons effectively. So if it means that it's going to have an impact on the running of the service, they can say, well, no, we don't think that you can do that. But they can't just say, no, we can't do that, it's going to be difficult. They actually should be saying why it's going to have an impact on the business and why they couldn't, for example, if someone's requesting 2 days, why couldn't they recruit someone to do the other 3 days? What is it that's going to have an impact on the business? What is it that's going to disrupt it? And if they don't reasonably consider it, normally you've got a right to appeal it. And I always say to people, if they've not considered it properly or not giving you a good reason, go through the appeals process. And we support and represent people very often through those appeals processes. And ultimately, if there's evidence that they haven't reasonably considered the request, there is the potential for an employment tribunal claim because they haven't reasonably considered it. And a lot of that will come down to actually what is the evidence that this is going to have an impact on the service? Why couldn't they consider whatever factors there is that could be considered? The other reason I said it's important to kind of lay out what your reasons are for that flexible working request is because if you are making that request because you have a disability, for example, and you no longer feel that you can manage, you know, the full-time position, but you could do 2 days at work, and your employer doesn't grant that, and it isn't they haven't reasonably considered it, there is the potential for disability discrimination there as well. There's the potential for other potential claims if it's for childcare reasons, for example, or caring responsibilities. So I think it's important to outline your reasons for your request at the beginning so that the employer has the whole picture as to why they need to consider this request. Because if further down the line you say, well, they didn't grant it and I needed it because of my disability, well, if you didn't put that in your original, you know, request, the employer can say, well, I didn't know that that's why you were requesting it. So it's always important to put your reasons for that request, you know, from the beginning. But the law around it is that they should reasonably be considering your request and giving you a reasonable reason if they can't accommodate it. It may be that they say 2 days is difficult, but we can do, you know, why don't we do 2.5 days so we can half fill your post? There's sometimes those discussions around that, but they need to give you those proper reasons really and why it's going to be difficult to run the service if you're working 2 days a week.
Yeah, thank you, Laura. Paul, is anything you would like to add to that?
That's a great answer, but perhaps I can just expand on 1 or 2 parts of it. The right to request flexible working, which is due to be toughened up in the coming months, but that's a long time coming, it seems to me. But the current right is just that. It's a right to request flexible working. In other words, it's not a right to work flexibly, which sounds silly, but in fact it's deliberately, again, it's a government choice to grant only a limited right as against your employer. So if you make the request, then provided that the employer can tick the boxes and produce a reasonable response saying, well, we can't deal with this because of service demands, then although you can potentially challenge it, firstly, it's difficult to challenge it because a tribunal will not look into the whole of the background to see whether the employer's conducted a sensible review of it. It'll be satisfied pretty much as long as the employer can't be shown to have utterly disregarded all the evidence. And secondly, if you win, you get, I think, is it 8 weeks pay, Laura? It's not a life changer, and it's a weak right, I think, that needs to be beefed up. And in relation to the much stronger argument for discrimination in these cases, that again has got its limits. And I don't want to sound like the harbinger of doom, but I think it's quite important usually as the lawyer in these things to say, you know, be careful what you try and achieve through the legal routes, because very often getting a union to negotiate a change on your behalf is less fraught, less difficult, and less expensive. So, but in terms of discrimination, the classic example is a woman returning, say, from maternity leave and saying, I now want to work part-time because of my childcare commitments. And tribunals have become very familiar with cases like that, and will put the employer through a rigor to make sure that the employer has in fact properly considered that sort of request. But very commonly these days what we're seeing is people saying, I have caring responsibilities that are not childcare responsibilities. I've got, say, an aging parent. And people want to bring a disability discrimination claim because their parent is disabled. So we lawyers talk about that as discrimination by association. So that it's not our disability that is concerned, but the disability of somebody with whom we're associated. And currently the law in relation to that is not terribly helpful. One would think in this society where we are meant to and encouraged to care for those we love and live with, that there'd be a way to have that sort of flexibility, specifically to encourage people to exercise caring responsibilities and wishes. And in fact, the law in the UK has historically said there's no right at all to flexibility because of the people with whom you associate. But there's a little change to that, just one speck on a windshield, so to speak, where another first instance tribunal judge has looked at this issue and has raised the question of, well, hold on, there's a European court decision in relation to Roma people, of all things, that suggests that you can, in fact, possibly bring discrimination claims via association. And it's another case which we're waiting with bated breath for an appeal for, because if the appeal courts agree with it, then arguably discrimination by association will be a thing in the UK. So watch this space, don't run out to a tribunal to do it tomorrow. I think it's going to be difficult, but it's interesting to me that that maybe is a way in which the law can develop in the next couple of years.
Thanks, Paul, that's useful. And I'm just putting together the other questions that just came in. So there's two parts, there's no two parts, there's two questions quite similar. So if you don't mind, Paul, I'll put them to you. And the first one is that my employer has changed a lot of my terms and conditions without consulting with me. Could you advise if this would be constructive dismissal if I left employment due to this? And the second question is around about a workplace is going under, it's going through restructuring, and how can this employee challenge this plan, and what grounds and how long to challenge it? So again, it's changed a lot of terms without consulting, and the second one's about reconstruction the organisation without engagement. Paul, are you okay with that? Would you like me to repeat that again?
I've got that. It's a huge question, or a pair of questions, but I'll try and address it fairly shortly. The first thing to say is that it's hard to resist a reorganisation simply by saying, I don't want you to reorganise. Again, a trade union might have ways at a collective level to try to suggest that the reorganisation should take a certain shape, but the law recognises that management has a prerogative to manage, and that might mean making even quite sweeping changes to the way in which a workplace is organised. It might mean redundancies, it might mean people having to apply for their own jobs, and it's often very difficult to challenge those things legally. What an employer can't do quite as simply is change your terms and conditions, and they can't do that either, necessarily at least, just because they're doing it as part of a reorganisation. So the law recognises that you've got a set of contractual rights, which hopefully will be set out in a written contract of employment, but some of your rights may be implied. They're not written down, they're not expressed verbally, but the law recognises that certain types of rights are implied into every employment contract. And if your employer fundamentally breaches one of those express or implied contractual rights, then you may be able to make a claim for constructive dismissal. And again, in full harbinger of doom mood, I will say that very few claims are as difficult in a tribunal as a constructive dismissal claim. For reasons that have never been terribly clear to me, everybody and his pal in the pub knows something about constructive dismissal and will say, if you're not happy at work, you can pursue a constructive dismissal claim. I've dealt with hundreds of unfair dismissal claims over 30 odd years in the job, and I think I've only succeeded with a constructive dismissal claim once. But the reality is these claims are awfully difficult to prove. It's difficult to show your employer has breached the contract because many breaches are not obvious or easy to prove. If the employer can be shown to have breached the contract, you have to quit. So you've got to leave your job before you know whether you're going to win your claim. And you have to do all this really quickly. And in one case where we acted for a director who'd been demoted, he would have won his case, but the tribunal said that because he spent 6 weeks trying to resolve the thing internally, he'd left it too long when he resigned. Now, in this case, the suggested facts given are that somebody has already left their employment. So if you've already gone, then there's a sense that it's kind of easier because you don't have to make the decision, should I jump? Because you've already left. And in that case, you've got to think, do I act now to go to tribunal? Because if you do, and Laura, I think, mentioned this already, that the time limits for doing this are very short. You've only got 3 months, usually less a day, to start a tribunal case. In an unfair dismissal case, that will be from the last day of your employment. So you'll need to act quickly. You'll need to prove, as I said, that there's been a fundamental breach of your contract, that you acted quickly, that you resigned because of the breach and not for some other reason. Employers often want to say, in their defence, well, you've not really left because of the way we treated you. You've left because you had a job to go to and you simply wanted to go to a different job. One practical tip in relation to that is get some help from someone, at least, and some advice about the letter when you resign, because all too often in these cases we're asked to advise and we see a letter where somebody says, I've enjoyed working with you for the last 10 years, thanks for all the opportunities and best wishes for the future, which is not terribly helpful when we want to establish that the reason that you left was that your employers have fundamentally breached your contractual rights. Does that help, John?
Words of wisdom, Paul. And Laura, anything to add to that?
Yeah, I think Paul kind of hit the nail on the head. But I mean, I would always say when we have people, and it quite often happens, people will ring and say, that's it, I'm just going to resign and claim constructive dismissal. And my immediate answer is no, don't do it, you know, because, well, there's two things. Firstly, as Paul said, they're really difficult claims to bring. And actually, secondly, you have to have worked somewhere for 2 years to bring such a claim. So don't do it if you haven't worked somewhere for 2 years, because you're not going to get anything. And also what you get out of it can be fairly limited, because if you get another job within a month, you go to a tribunal and you get your losses awarded. Well, you've spent all that time and effort to get a month's worth of your losses if you're lucky. You know, I always say to people in any situation, if you can avoid legal processes or litigation or whatever, then avoid it, because it literally is the last resort and they're not easy things to go through. But yeah, please don't just kind of hand your notice in and say I'm claiming constructive dismissal without at least talking it through with somebody first.
Thank you.
Somebody who's qualified, somebody who knows what they're talking about when I say that, you know.
It might interest people to know that in some parts of the country, the delay between starting a tribunal case and getting into a hearing, especially if you've got a complicated discrimination case, can be 12 months to 2 years. Even in the parts of the country where the tribunals have caught up post-COVID, 6 to 9 months is not uncommon. So this is a nuclear option with potentially no guarantee of success and a long delay built in. And as Laura says, litigation, I'm doing myself out of a job here, but litigation can be toxic and stressful and in the end not terribly productive. So think long and hard before you go down that path.
Thank you, Paul and Laura. The wonderful world of employment. But we'll move on to that. The next question just came in. It's quite a short question actually, so it's good. I can make sense of that. And Laura, if you're happy to answer this one, it says, what are my rights to request flexible working. So how's that managed?
I think I've potentially already covered that with the earlier answer. Both myself and Paul, really, you have a right to request it. As I've already said, that is a legal right. If you've worked somewhere for 26 weeks or more, your employer doesn't have to grant it, but they have to reasonably consider it, in a nutshell. And, you know, again, get some advice and support from us if it's something you're considering, you know, applying for, because we can advise you on your individual application.
Thanks, Laura. And Paul, I'll just skip into something, just only because it's topical, because it's related to the last question. Someone's asked, how long do you have to access after restructure to ask for a redeployment as your original job role focus has changed? So I'm not sure if that's putting you on the spot there, but it's just because it's quite topical for the last one.
That's an interesting question. These things are often really fact specific, and in a talk like this, we can't get into all those individual details. But the answer really will be, how much has your job changed? If it's changed sufficiently, but you've not been sacked, you've just been told you'll now work in this way in the future, then your answer really is either to live with it or to quit, because there's no way in law to say to your employer or to compel your employer to undo the changes that they've made in the restructure. So what are we left with when you resign and claim, you guessed it, constructive dismissal, which we talked about just a few minutes ago, which is a hopeless and difficult and often not very effective remedy. So that the answer again is get union representation if you can at the earliest possible stage before the restructure happens, in the hope that you can, with the help of your rep, negotiate changes that suit you. Because once the changes have taken place, then your options are really limited. What we don't have currently is a way sensibly to deal with disputes about contractual disagreements, if you like. If your employment's still continuing, the tribunals can't hear, ridiculously, a breach of contract claim until you've finished employment. And I've thought for years it would be fantastic to have a tribunal mechanism where you can take exactly this sort of issue, somebody saying, my contract's been messed with, the focus of my job has changed, the restructuring has really changed the way I'm working, to be able to not leave, not to have to quit and claim constructive dismissal, but instead to go to a tribunal and say, can you look at this arrangement and tell the employer to treat me in a better way? That would be terrific, but it's not part of the law of the land today.
Thanks, Paul. I'll just keep you there if you don't mind. It says, I've been off work for 3 months with work-related stress. Am I protected by disability discrimination law? And similarly, another question is quite similar. I put it together. It says, I've been off sick with work-related stress. Might I be able to pursue a personal injury claim against my employer? So one person's asking, are they protected with disability discrimination law? The second one is, might I be able to pursue a personal injury claim? Over to you, Paul.
Thanks, John. So I'll deal with the disability point first. You're disabled under the Equality Act if you have a physical or mental impairment that has a substantial long-term adverse effect on your ability to carry out normal day-to-day activities. So it's a bit of a mouthful, but effectively, if your day-to-day activities are hampered in a more than trivial way, and if that impairment lasts for more than a year, then you're probably classed as disabled under the 2010 Act. Work-related stress can be a disability in that context. It's not always, and the GP who simply writes work-related stress on your fit note is not helping you in relation to that, because a tribunal will take some persuading that a couple of fit notes saying work-related stress is sufficient evidence to amount to proof of a disability under the Act. And it needs to be long-term, I'll repeat that, 12 months or more. work-related stress is sometimes significantly less long-standing than 12 months. So if you don't get over the 12 months hurdle, then you can't pursue a claim for disability discrimination. But assuming for a minute that the stress is sufficiently substantial that it affects your day-to-day life, and assuming that it has lasted or is likely to last over a year, then yes, you're protected, because, as I've said, disability discrimination protects both physical and mental issues. And in fact, we're seeing an increasing number of mental health issues being brought to tribunal under the disability discrimination protections. And disability discrimination works a little bit differently from the other types of discrimination, in that not only are you protected from direct discrimination and harassment and indirect discrimination, but your employers have a duty to make what are called reasonable adjustments. So if the physical arrangement of your premises or your working arrangements or the lack of auxiliary aids, for example, substantially disadvantages you at work, then your employer has a positive duty to go out there and change those things if they can, even if that's going to cost them money, to put you on a level playing field with people who don't have that disability and that disadvantage. So certainly you're potentially protected, but again, it'll be fact sensitive in each case whether your condition qualifies as a disability under the Act. And actually, the second question about whether there might be a personal injury claim ties in quite neatly with that, because again, for simply work-related stress, chances are you're not going to make a personal injury claim or get it off the ground, sorry. You need to be suffering from a medically well-recognised condition. So that might be, for example, clinical depression or mixed anxiety and depression disorder, or one of the recognised conditions that's not necessary for the purposes of disability discrimination law, but you want to pursue a personal injury claim, you're going to have to show that, again, you're over that barrier. So there's a hurdle, if you like, that you've got to get over. Secondly, personal injury claims for work-related stress are very hard to pursue, and usually they depend on whether your employer should have known or did know that what was going on at work was likely to affect your mental health in such a way that you would suffer injury because of it. And the issue that we've got in 80 or 90% of these cases that come to us is that the employer can say, we didn't know, you never raised it. By the time you were off sick with it, it was too late for us to fix it because you'd never told us about it. And Laura talked earlier about the importance of raising these issues and getting advice early, ideally, again, from union reps who know what they're doing and who've come across this before, and of writing to your employer if needs be. And I know that SWU will help you with this, to say, you're affecting my health by the workload you're imposing, the lack of support, the bullying I'm experiencing, whatever those things are, set them out in black and white, because as soon as that's there and out in the open, so to speak, the employer's arguments about, well, we couldn't have foreseen this, become more tenuous, don't they? Because plainly the employer knows about it. So for me, it's about creating that paper trail at an early stage. If things do then deteriorate because the employer refuses to tackle the problems that are causing you to be poorly, then your chances of getting somewhere with that increase. That said, one claim in 100 for a personal injury for stress succeeds. They're really difficult. Much more likely is the law to come to your assistance if you can claim disability discrimination. That's an area where unusually perhaps the tribunals are really sympathetic to and positively hold employers' feet to the fire about failures to deal with people who have legally recognised disabilities.
Thanks, Paul. We've got 15 minutes left. I've had a few other questions coming in. I'm impressed as ever getting through all these questions from the answers, Paul and Laura. So thank you, Laura. I've got a question. I might put that into two questions, because the first one is, I've been sick during my holidays. Can I take the time as sick leave? And and preserve my holidays. So can I carry over holidays to the next holiday year? And the second question is about somebody's rights to occupational health, as I had to provide my manager with all the personal information. And then unless I spoke to my manager about my condition, which I didn't want to, I was denied access. So do they have to disclose everything when they're requesting occupational health? And the question below is regarding sick. So I've been sick during my holidays. Can I take time as sick leave and preserve my holidays? Is that okay, Laura? Would you like me to go over that?
Yeah, no, that's fine. I think I've got that. I'll touch on the annual leave and sick leave issue first. If you have been sick when you were supposed to be on leave, then yes, you can call in sick to your employer and say I'm off sick, and you should not have to take your annual leave if you are ill, basically. In a nutshell, I think whether you can carry your leave over into the next year, yes, you can. If you've been off sick for a while, for example, and you've got leave that you haven't been able to take because you've been ill. Because as I say, you shouldn't be forced into taking your leave when you're off sick. Having said that, you're only legally entitled to carry over your statutory entitlement to holiday, which at the moment is 20 days a year. So if you're a person that gets 25 days holiday, for example, or annual leave, legally your employer only has to allow you to carry over 20 of those days into the next year. But it's worth checking your employer's policy, because sometimes they'll say with the manager's discretion you can carry over so many holidays. So it does depend on what your employer's policy is as well. So I would double check that. But like I say, legally they only have to allow you to carry over those 20 days and not anymore if you do get more holiday than that. I think touching on the occupational health issue, it is a difficult one because quite often people are struggling with things that they don't particularly want to disclose in detail to their manager or their employer. And I think it's about getting that balance, because normally it would be your manager, sometimes HR, but normally your manager who would refer you to occupational health. And the purpose of occupational health is for your employer to be able to ascertain what your health condition is and what they can be doing or should be doing to support you in the workplace and support you back into the workplace. So occupational health and your employer can only go on the information you provide them with. And this comes back to what I was saying earlier on in terms of, if you can choose what you disclose as part of your medical, you have a right to disclose exactly as much as you want in terms of your medical information, because it's confidential information and you have a right to, like I say, to keep that confidential or to disclose it. The problem comes when, if you are having difficulties and they are in relation to your health issues and you haven't told your employer about them, the employer can turn around and say, well, how could we support them with that when we didn't know about that? So it comes down to what is relevant for you in terms of what you need to tell your employer, in terms of what they need to support you with. And ultimately, I think it's your choice. You don't have to have an occupational health referral at all. But if you don't, the employer will turn around and say, well, we were limited as to what we could do to support this person because, you know, they weren't accessing occupational health. So it's about getting that balance right. You don't have to disclose everything personal and sensitive if you don't want to. And if you don't think actually that's going to have an impact on what your employer can do to support you, then don't disclose it. You know, disclose the important health information that you think is relevant to that occupational health referral and to what is relevant to how your employer can support you in the workplace.
Thank you, Laura. And I've got a few other questions in, so my apologies if I don't get round to all the questions, but again, we'll do our best. Was there anything to add to that, Paul, that bit of advice from Laura?
Good advice from Laura. I'd throw in probably that in relation to carrying over the 4 weeks basic holidays, the courts have now said that there's a limit to how much you can do that, and probably the period of carryover is up to 18 months. So don't think that you can carry it over forever. And as Laura rightly says, not all of your contractual holiday is necessarily carry overable. And in relation to the second point, it's interesting very much how that ties in to the thing we were talking about 5 minutes ago in relation to disability discrimination and personal injury claims. And again, if you want to make a disability discrimination claim, your employer can't discriminate against you if they don't know that you have a disability. So disclosing that whilst you've no obligation, as Laura says, but it's going to be a prerequisite to bringing a claim or making demands for reasonable adjustments. Because if your employer doesn't know about your disability, then they can't be expected to fix it, is what a tribunal will say. Likewise, as I said, for a personal injury claim, so much of those claims is about foreseeability. And again, the employer can't be expected to foresee that which they don't know anything about.
Thank you, Paul, and I'll stay with you here, Paul. So one of the attendees said they've applied for a promotion, but in the interview, the internal interview, it was suggested that the new role was suitable for a candidate with a vibrant, dynamic, youthful approach to work. And this person's 45. Can they turn me down for this position? So the person's asking, can they be turned down?
I'd like to think I was vibrant, dynamic, and youthful at 45, John. Yes is the answer. They can turn you down, but if they do so, then they're at risk of an age discrimination claim. So age is one of the protected characteristics that we've been talking about, and there are a number of cases where this kind of wording has in fact been used in newspaper adverts and similar, or in the workplace where employers suggest that what they need is a new sort of what's the word I'm looking for? Enthusiasm. And tribunals have been prepared to say, well, some of the qualities that you're describing, in fact, are qualities that really equate with people under 25 or whatever. So even if they don't use, in your example, John, in the question there, we talk about the description saying vibrant, dynamic, and youthful. So obviously there's a specific reference to age, or at least an age range. But I don't think you need to be, your employer needs to be as honest as that about what they're looking for to be potentially falling foul of age discrimination law. If the requirements of the job are such that indirectly they exclude people of a certain age, and this can work both ways too. So requirements, for example, for really long periods of experience, they'll be scrutinised by a tribunal, because if you want 20 years experience, that's probably going to rule out anybody under 36 and probably under 40. And the question is, well, why do you want 20 years experience? I mean, there are not many jobs where 20 years experience is required. So it can work both ways. It's not just requirements for youthfulness, but requirements for age and experience that disqualify or disadvantage younger applicants. All of those things can result in an employer facing a claim for age discrimination. They can justify that kind of claim if they have objective, proportionate, legitimate aims to try to achieve. But it's really hard to do, and tribunals are very much alive to the fact that employers might want to have a workforce that's under 25 and looks it, but they'll be very much alive to employers who try to dress it up in a way that hides that. And they're quick to say that whilst the words used might not be ageist, the effect of them is to create a barrier to those in a certain age group, be it older or younger.
Thank you, Paul. And Laura, vibrant, dynamic, and useful have been applied to you many a time, I'm sure. So I'll maybe move on to the next one. We've got 7 minutes left. So if you don't mind, Laura, it says, I have dyslexia and have been criticised by my manager for slow report production. Am I entitled to extra support? So someone's around.
Yeah, I think this comes back to the issue we've talked about quite a lot tonight in terms of disability discrimination. Because technically, I think you'd need to look at whether the dyslexia could class as a disability. There have been cases where it has been considered a disability, and that comes down to the fact that it's a long-term condition, which ticks one of the boxes, and the other criteria is that it has a significant impact on your day-to-day functioning, basically, in your daily life. So if your dyslexia does have an impact on the efficiency in which you can write reports, and would have an impact on, the fact that you may struggle to do reports at the same speed as your colleagues, I'd say it's likely that we would be looking at potentially that falling under the disability criteria, so to speak. So then you look at actually should your employer be making reasonable adjustments for you? Yes, because you have a disability. And it's surprising, but we do get this kind of thing coming through quite a lot when we're representing people, far more often than I would hope when people are working in social work, to be honest. But your employer should be looking at what they can put in place as an adjustment for you. The most common thing that we see is dragon software, for example. You know, any kind of software where someone isn't having to, you know, it gets that support in terms of being able to access that software to do reports. Quite often there are other things that can be put in place in terms of extra protected time to complete reports because things are taking longer. If someone has dyslexia, sometimes people need to have things that they can put over their screen to enable kind of help with reading difficulties or that kind of thing. Access to work assessments are always really helpful, and we tend to tell people contact access to work and refer yourself to that service. There's about a 4 or 5 month waiting list at the moment, unfortunately, but they will do a detailed assessment with you where they talk about your dyslexia, how it impacts on you on a day-to-day basis, and then they would do a report for your employer, which will identify how your dyslexia impacts on you and what they should be putting in place to as reasonable adjustments for that. Sometimes your employer can get some kind of financial support with that as well. Really worth doing, but also I think talking to your employer about what it is you think would be helpful. Just as a start, dragon software or a similar kind of software may make a big difference to you. So in a nutshell, yeah, absolutely, they should be making some adjustments, and you need to have those conversations with your employer as soon as possible. And I would always suggest doing it via email as well as verbally, so you've got a record of the fact that you've raised it with them as a concern and what you think might help you.
Thank you, Laura. Excellent answer there. So I'll just move on to them quickly. We've got maybe just over 3 minutes. We'll do our best. Paul, if you don't mind, this question says, I've been bullied in my workplace. I did not go through the work procedures due to a bereavement, which meant I was unable to make decisions at the time. Is there a time limit to make a complaint?
Yeah, it's very difficult. If the bullying related to a protected characteristic, so if it was because of your sex or race or disability, then you can potentially pursue a claim for, say, harassment under the Equality Act, and the time limit for that is 3 months less a day. So if you were harassed on the 31st of January, then you've got 3 months less a day, which is going to be February, March, April. The 30th will be your last day to start a tribunal case. Sometimes time can be extended, and if you've been very ill, and this question is about a bereavement, and if that bereavement has resulted in a grief reaction that is sufficiently severe, then sometimes a tribunal will extend time, but it's not easy to do. The thing about bullying is that it tends to be an ongoing state of affairs. So it may be that if the bullying is continuing, that in fact you are still in time because the events that have happened form a series. And in that case, your 3 months runs from the last date in the series of events. Let me say this though, if your bullying is not related to a protected characteristic, then again the law really lets us down, because there's no right to pursue a claim for bullying per se. If it's unrelated to a protected characteristic, then although you can follow a grievance internally or whatever, your legal right is, we go back to that old chestnut, resign and claim constructive dismissal, which is hardly where you want to be in terms of your legal protections when you've been bullied at work. But that's where we stand today.
Thank you, Paul. And I think we need to conclude there. The final question I was going to look at was to do with our students, but it also covers bullying in the workplace as well. So I think, Laura, that would be quite pertinent to Paul's previous answer about how do they challenge that. I'm just about a grievance. Yeah, I'll leave that one. And that's quite a long question there. And if you are a member, then I'm sure that you could discuss that with our duty desk. So we're coming to the end of the session. Again, it's been a delight. And I've been John McGowan, General Secretary. We've been the Social Workers Union, and thanks once more to Paul and Laura. Always impressed by your knowledge and the way you answer the questions. So thank everybody and good night. Thank you.